Recording in progress.
Okay, welcome. We'll call to order the June 7th regular meeting for the Aspen Pitkin County Housing Authority. Cindy, will you call the roll?
Yes. John Ward.
Present.
Allison.
Yes.
Carson.
Here.
John Doyle.
Here.
Ward.
Here.
Kelly.
I am on the phone.
Great. So,
Is
Francie's
Francie
not-
there? Because she was going to cover this meeting. I was just calling in for the consent agenda.
I know, and she has not joined yet. She told me she was going to, but she's
Okay.
not here yet.
Okay, I will hang on. then. Thank
Okay.
you.
Thank you, Kelly. Okay, we have a quorum, so we will move to public comment. Is there anyone wishing to make public comment, either online or in the room? All right, not seeing any. We'll close public comment and we will move to APCHA Board of Director comments. We'll start online. Kelly, did you have any comments today?
No, thank you, Carson.
Thanks, Kelly. Ward?
I have point of order. If Kelly drops off and she's only county commissioner here, can we continue?
Yes.
Okay.
Right, or no?
I don't think so.
I thought once the meeting started and we had a quorum. Is that not right?
I think you have to
Okay.
maintain your quorum.
Okay.
I think for this, we always have to have a city person and a county person.
Right.
We could
That's-
No, we have to
That's-
have us too.
When we did the IGA, that was in there, that
Yeah.
one representative of each
Can someone reach out to Francie?
elected.
Okay. Let's see.
So stay with us, Kelly.
Okay.
Okay, sorry, I'm just in not a great spot, but doing my best.
I'm gonna try
Okay.
to contact her.
Did you have any comments, Ward?
No.
Is that it? Okay. John Doyle.
No comments.
Allison?
Yeah, I have several comments. In no particular order. One is, I guess, more of an acknowledgement. We've heard this before, and I think I know the response, but I've heard again a report of someone losing their Castle Ridge lease with a couple weeks' notice, having never been out of compliance, having, paid rent on time. And so with a private landlord, operator, I know we can't do much, but this is not the first time we've heard this. I know City Council has had people go and tell their stories. I can't help but be suspicious, I guess. Why would you cancel a perfectly good lease and put in someone else unless there was a benefit to you to have that other person? I don't know who would even investigate that or what kind of relations we have with Castle Ridge, but I am very disheartened every time I hear the story, and it's been years, and it's not infrequent that I hear that from tenants of Castle Ridge. I guess, I wanted an update on the right sizing program, which I believe opened. These next comments are all kind of intertwined. I'm very much looking forward to our retreat. Is that what we're calling it? Just, I think, for some communication and getting on the same page issues, between staff and board and community. I know APCHA staff is so good at what they do, so knowledgeable, and works very hard. And I know the community thinks that APCHA is really hard to understand, get a hold of, not transparent, bad at communicating these things that we're hearing from the public. And when we were asked the frequency of meetings and the time of meetings, I said at the time, I think holding those steady is going to be the best way for public comment to happen. Holding those at 4 o'clock, if not 5, is a much easier way for people to participate in public comment. I think this meeting at 3 o'clock was very hard for me, who is committed to being here at every meeting, to manage with my work. I don't know how someone would stop their work at 3 o'clock and come and go to public comment for something like this. So But also, I think those off meetings, like I know we didn't, so now it's been a month since our last one. I know we didn't have the previous one, this one in the middle, for some scheduling reasons, but I think a meeting like that is when we could use like work session time. Just open it up for public comment. If people know what Wednesdays we are meeting and when, they can rely on us and feel like we are accessible. 2, isn't that a great time for little updates, like the right sizing program, and some time for us to have work session style conversations? And this will come up in our consent calendar, but my understanding of a resolution that is in front of us today was that we did want more discussion and we wanted some answers. We wanted to float some other ideas, and for that to not have happened and now be asked to vote on something feels like we are missing that connection that we've
It's
asked
not
for.
my understanding from the last meeting. My
That's-
understanding from the last meeting, you wanted a formal resolution to come forward, and you agreed to this. That was my understanding.
Carson?
Yeah, I mean,
You can pull anything from the consent calendar if.
yeah, I mean, in the last meeting, I think there was a broader discussion, right? And I think the way I understood this was that there was a piece of this that we wanted to advance and then continue on kind of that broader discussion, right? So I think this specifically was to accommodate anyone wishing to completely scrape the place, put a new property on, and then I think there was an expanded conversation that will still continue about how do we handle capital improvements, how do we, if we just sort of that larger discussion. That was my understanding.
Thank you. So I guess my case in point is those other conversations where we want to have a broader time. I think that off week could be used for things like that. Those kind of more free-flowing among the board conversations, little like not relying on staff time to get the full memo and direct it, but allowing us to have that conversation in that manner. I don't know, should I pause for a right-sizing response, or can you include that in one of your updates? Wonderful, thank you. Along the same lines, I was asked how to contact our board of directors, and I actually don't know the answer. I'm wondering if we can get an account, the city council, and I believe county has something like public comments at. Is there a way that someone can find a way to contact board members on the website and not have to track down all their individual email addresses, just a generic spam the board type?
Just an email address
Yeah,
for a board member, that's, I don't know if it's APCHA or City of Aspen or whatever it is, but then.
and maybe it goes to Cindy and she forwards it, and even if that email address is to submit comment to the full board, right, Cindy Christensen at aspen.gov, something, again, and that alleviates my concerns about the consistency of pattern and time for public comment opportunities. If we have that other option, you can write to us anytime because you found that option on the website. So that has all come up in my APCHA periphery in the last week, and I think I just kept writing it down in the notes. I think I hit my list, and I appreciate that.
Thank you, Allison. John?
No real comment. I agree with your comments on it. I think this was specifically for Shamey, that has plans and they're pregnant and they want to move forward.
Right.
But yeah, I think we're going to have a broader discussion on the rest of the.
Yep. Great. And then I'll just echo your point about the comments. I'm looking here on the website. There's no contact information for the board, so I think
We'll add something on it.
finding something there would be good. Okay. We'll move to executive director's comments. Matthew.
Good afternoon, everyone. I do have some updates. So the right sizing is live. We have not made any matches yet. We've had quite a few. We've had a handful of inquiries, 10 or so, mostly on the I want to upsize side, but we have not made a match yet, but we're still working on that.
No offers for downsizing.
There's been some tentative.
Okay. Tell me more about this.
Right,
kind of-
but
okay.
nobody's actually. So we have not got a match yet. But we did the press release. There was several articles in the paper, and we'll keep publicizing that. But we haven't hit it yet. We're excited for the retreat on July 19th. We had a good sit down with John Doherty last week, who's our facilitator, and we've got I think we've got a good program for you guys. It's going to kick off with Tom and Diane just going over the IGA, what is the role of the board, how it all fits together. Then I'm going to go over the strategic plan, this year's work plan, and do a brief session on ideas for next year's work plan. And then I'm going to turn you over to John. And John's really going to be, he's very excited, and he's got a lot of deep knowledge on developing skills and having you guys do some deep thinking about about your role in the board. So that'll be John's job, and we're going to do it at the Inn at Aspen, otherwise known as Home Team Barbecue. So we'll give you a nice lunch. They said it's deluxe tacos, so that sounds very fancy. So yeah, so it should be really good. And then the day before, Ward and John get to spend all day with me as well, because that is the city and county. They're going to have a day-long session on affordable housing. You knew that, right?
Of course.
Okay, good. So it's lots of affordable housing work in July, and then Allison's leaving the next day, right? Allison's out.
Then I'm out.
So the timing works well. And then the other thing I wanted to flag was Liz and I are going in front of the city on Monday night for the Essential Grants Program, the Maintenance Grants Program. We had a very successful meeting with the county 2 weeks ago. So I wish Francie and Kelly were here in person so I could thank them. They did a great job shepherding that through and answered some great questions, some policy questions. But we asked the county to give us $100,000, and they said, no, we will give you $200,000. So that's the bar for the city to look at. And so they doubled it, and so we're probably going to go with $10,000 grants rather than $5,000 grants, and they had some good input on including the building performance standards team and CORE and kind of a advisory role. We didn't want to build out a formal thing, but we're working with CORE and the BPS folks, and when this gets live, we'll have them discussing some of it with us. And I'm going to leave it there. So thank you very much.
Thank you. Cindy, any notifications, available rentals and sale units?
We had four bid periods that ended, or will end at 4 o'clock today.
Okay.
And then I believe we are adding one for next week, and it's going to be a Hunter Creek unit. So definitely make sure you check on our website, sign up for notifications. I'm not sure about any new rental units that have come up. I know we're still working through our list. We're having some more positive luck with filling some of the T2 2-bedrooms and the ACI, because the income levels for low-income housing tax credit went up quite a bit for 2 people. So we're seeing some positive move in that direction as well.
Thank you, Cindy. Okay, I don't have any agenda amendments that have been brought. If anyone has any, make those known now. Next item is the consent calendar, and we've got the minutes and resolution number 4. I'm going to go ahead and split those, given Allison's comments. The first item on the consent calendar is the minutes of the May 3rd, 2023 regular meeting. Motion to approve those.
I'll move to approve.
I'll second.
Okay, and because we still have Zoom meetings, it is a roll call vote.
Okay. Kelly?
Yes.
Thank you. Ward?
Yes.
Carson?
Yes.
Allison?
Yes.
And John Ward.
Yes.
Okay, and that moves us to resolution number 4, series of 2023, approving owners of Smuggler Run to enter into an updated deed restriction to Category 5. So as we talked about earlier, this is the intent here was, as I said, to move forward with part of this discussion specific to those properties which will be replaced by a new
And that
new
is in the
structure.
resolution.
Correct.
That
Yep.
is noted in the resolution.
So any, I guess,
So real quick, Cindy, I got a question on how you're gonna value something like this, right? So Shamey's, who went out and bought the property, it needs to be scraped. They're gonna do some work, they have to do some retaining wall work and some other things on the property. Bring in I'm assuming a manufactured home. The valuation will be max category 5 or whatever that number is, or is it minimum category 5?
No, it's max category 5 for
Okay,
now.
max category 5 at the time of CO, recording,
time of
what's the
CO.
story? Okay,
They have to provide all their receipts, and if they're over, it will be maxed at that. If they're under, it will be what they actually spent on it. Health and safety items like the retaining wall, they also can do what we classify as 10% capital improvements and safety issue items. So we plan on allowing, if they're over, and they can provide us documentation of what they spent for some safety items, it could go a little bit over what that maximum price is at the single-family home for category 5.
okay, so let's bring
But
up
that stuff depreciates down.
the next scenario, which is the rest of the homeowners in Smuggler Run, right? We got an email today from some homeowners just questioning their ability to do improvements, and I don't necessarily call these improvements, I call them maintenance items, a lot of them. But we move them to a category 5. Some choose to, scrape and replace, like the Shamies are doing, or some choose to do some maintenance. How are those maintenance items gonna be?
If they're capped, they can go under a brand-new deed restriction. So they start
So they
out
get
with an
10%
additional
again.
10% cap, and they have to be classified as capital improvements, as stated in the deed restriction.
Aren't there some improvements that they do that then are depreciated?
Yes, all the capital improvements are depreciated
Okay.
down.
Okay.
Our energy savings, greenhouse gas reductions, I thought those,
That's above the 10% cap as well. But again, everything that they do is depreciated down. We have a specific depreciation schedule that we use. We don't arbitrarily put numbers on it. So some might have a 30-year life, some might have a 5-year life. We work with what we call the Marshall Swift Handbook, and that has an appreciation schedule, and we've used that since I can remember.
Okay, any other questions for staff on this?
Yep.
Allison?
Hey Carson, I don't know if you can see my hand.
I cannot. Kelly, go ahead.
Okay, thank you. I'd like to understand a little more clearly. So when their max category 5 number is calculated, is that calculated upon the new deed restriction that they enter into, or is that calculated upon when they sell the unit?
They get when they get their certificate of occupancy, and they provide all the receipts to us. They go under a new deed restriction at that time with that price.
Based on the cap.
Okay. And then how many other mobile home parks are currently at category 4?
None. 0.
And the only other category 5s are Woody Creek, or is there others?
No, Woody Creek is the only category 5.
Everything else RO.
The others are RO.
Okay. Okay. And then I'm just wondering, is permanent foundation, is that clear terms to the building department?
I would think so. I don't
We
know,
haven't
but
had a
I would
problem,
think
yeah.
so. Yeah.
Are the current mobile homes purged to the
Okay.
foundations?
They're all purged right now, they have to be. Some of Woody Creek are not. No, all of Woody Creek is. Some of Lazy Glen is not, but, yeah.
Could you purge?
That means that you can go on the assessor's website, and if you pull up all the Lazy Glen, on some addresses, you're gonna see two. You're gonna see what is called a R something, I believe, and that has to do with the structure. And then an M, the M is the mobile home, and then the R something is the land. They have it as separate, because they haven't gone through the process of purging the land with the
Well, so,
unit.
so a mobile home comes with like a title, like a car, right? And so you're taking the title and purging it to the ground, so then it becomes an improved structure to the land. So then that's part of the valuation, when you scrape it, put something new in.
Then it becomes one instead of two.
One, yeah, it's different, and lending can make a difference too on how you can lend on it.
Smuggler Run, they're all purged. They all own, everything is one.
Any other questions for staff or?
Yeah.
Kelly?
No, I guess I would just say, Carson, I mean, I think this is improved in the sense that it's not a blanket increase to everybody. I still think we're kind of not talking about the right problem, honestly, that, we should really be thinking about, like, how do we look at program-wide these type of incentives. I do think that this will just probably create some problems we'll have to deal with, or other demands to then become RO. And, are we answering the right question with the right solution in terms of looking at maintenance in our program and the conversion of mobile homes? So I struggle with that. On sort of a separate note, I've raised the issue with our board, some desire to have a conversation about, can we do more in terms of offsetting or subsidizing permitting fees, et cetera, for affordable homes, deed restricted affordable homes in the city and counties that could go through the building departments. But I just wanted to throw that out there.
That's for further discussion. That's on our radar, just to let you know.
John?
Well, so real quick, there's no technically added value, right? We changed the category. The value still stays the same. Now, if somebody goes and spends the money, on improvements or scrapes and rebuilds, there's where the value gets added in, right?
Right.
Yes.
And so ultimately, there's no game to add the value. I do think this, this is another mobile home park, much like we talked about in Woody Creek on our pilot program, which we have all rights to do anyway, to buy, scrape, and replace, and then, keep the category, keep the cost, whatever the price is we want it to be. My question then becomes, and it's a broader question to everybody, is like, where do we want our categories? How do we want these units categorized long term? Is category 5 an okay number? Or do we still, do we want to maintain category 4? Do we want to maintain category 3? I think these type of units require more capital intensive maintenance. Category 5 probably makes more sense, right? Because, ultimately you can maybe recoup something, but nobody's guaranteed to recoup anything in these programs.
Right.
Well, and John, I just want to jump in, because those are some of the thoughts that I'm having about this. And I guess the difference is when we opt into buying and replacing something, it can have the features and standards, for energy efficiency, for design, for permanence, et cetera, that we want. Whereas sort of under these one-off ad hoc programs, if we should decide to want to keep something at a lower category and re-subsidize it, we have much less control over what that unit looks like and how it functions.
Yeah.
So that's why
all
I
of
feel
that
like
stuff,
we're
the energy
missing,
efficiency,
the broader
everything.
conversation is important.
Thank you, Kelly.
I agree with that. I think the premise behind this, I'm very much in support of. I think my issues are procedural. I'm glad you brought up the Woody Creek pilot program. I do feel like we had this great idea for a pilot program. tried to impose it on a mobile home park that didn't want it. And now we're kind of being asked to do it at a different park. And so I'm wondering if it could be our test case for the pilot program.
Well, we had that shot. Because we could have not sold to the Shamies, done the same thing, and then sold it to them in the end, but we let her buy it.
And just to be clear, 16 Ajax is separate from this conversation. We have already allowed the exception for them. Is that correct?
No, this approves
This
that.
would allow them.
If
Okay,
this
so
doesn't get approved, then they're stuck at 4.
got it. Which will affect them when they go to sell. I mean, it won't help them one way or the other unless they sell.
I think,
No, it helps them, doesn't
yeah.
it?
They won't be
They-
able to get a
they
loan
can't-
if they can't go
build.
up to the category
They've
5.
told us they can't,
Okay.
they won't be able to build unless they go up to 5.
Because they need the loan to do it. And then, okay. One just procedural. So a resolution is something that we declare, but it's not like it goes into the regulation. I guess I want a little clarification of resolution versus regulation because I am wondering about the precedent setting and the fairness of doing this for one specific HOA neighborhood.
Want me to handle that one, Carson?
Tom?
So the regulations are, most of the time, well, they're supposed to be all the time, but there are a few quirks. But they apply generally across the board. They're not intended to focus on any specific project or any specific property. So when you deal with a specific property, you deal with it with a resolution. And that's why it's in this format. Now, if the board were at some future date to decide that you wanted to allow any Category 4 unit in the inventory to go to Category 5 under similar circumstances, you'd adopt a resolution that says, okay, now we're going to make this a program-wide opportunity. In this case, it's being done, as I understand it, because unlike some Category 4 units, these units are in such a deteriorated state that there is, at the Category 4 maximum resale price, there's zero incentive for anybody to undertake those expensive improvements. They can't possibly get their investment back. Now, they don't get it back under this program. You don't get it back until you sell, but you have increased your equity by going to Category 5.
You get some kind of as-complete value,
Yes.
essentially, right?
Right.
Thank you for that explanation. So again, I think Kelly mentioned the ad hoc nature of this, and that is a concern of mine. As far as precedent setting, we know why it's relevant here and not other, like a condo that's also been in disrepair and falling apart, or other housing examples throughout our system. But I think in explaining that, or shooting someone else down who also cannot afford to get their place up to, it would cost more than they could resell it. It does feel like we're picking and choosing, and so it's hard for me to do in that piecemeal. I want to clarify: is Smuggler run on a deed restriction that could go to free market at some point?
Some,
No.
yes,
Yes,
Some
it
of them are.
expires?
some of them are.
That would-
Some of them go away in like 50 years. There's a couple of the units there that they go
Okay,
away.
so there isn't one uniform deed restriction
No,
out there.
there is not.
What I would love, and maybe this is in that as read, is if any of those elect to be part of this program, and so they do come under APCHA deed restrictions, that we'd be able to get some of those into perpetuity. Is that,
That will happen.
That's all would
this
happen.
would cover that?
Yeah.
Fantastic. And then, so my issue too is just, under our rules and regulations, you can only bid up a category. So we're just resolutely saying, no one in Cat 3 will ever have access to this neighborhood. Like you're out because we're moving it up, and I just want there to continue to be options for people who make lower incomes in our community, that are beyond rentals, that are beyond a one-bedroom condo. And this is a very unique type of neighborhood within our mix, in our city limits. And the benefit to the homeowners for helping us improve helping the system get improved by getting rid of dilapidated buildings, putting in brick and mortar, putting in something that will last a lot longer. And then there's something you said about it not returning, but once it's a real house, it's actually going to be much easier to maintain, I think, than some of our old condo buildings, because it's yours. You're in charge of everything.
Well,
you're not dealing with capital reserves that are underfunded, and so I think that goes actually away. That point.
Maybe you share those costs between 12 owners in a condo building. You got those costs.
But if they've been underfunded for 35 years, I mean, you're.
Sure.
So I think, this was my main concern in the conversation in May, is I don't know that we've considered the full effect of who we're now eliminating this chance for. And those are my comments.
The thing of it is when you look at single-family homes, you cover everything. You have to do the new roof, you have to do everything. You're not paying homeowners association dues into anything to take care of roofs or whatever later. You have to take care of everything. So that the prices are higher when you own a single-family home. And that to me is if you have single-family homes that are category 2 or 3, it's a possibility you're doing a disservice to them because they can't keep up with it.
I think the point of an affordable housing program and kind of socially engineering this way is that we know there's jobs in this community that will never, you can have that job for your whole career and you will never make enough to really make it here. And having a program where you still, as a family, get a shot at a single family home is the idea of a subsidized housing program. And so this kind of is just telling you if you never make enough money, this is out of reach for you as well. So that's my concern. None of this is to the point yet where I'm going to try and get you guys to not approve this and I am so excited that we can continue talking about the rest of it. I do think Brittany 16A Jack should move forward, and the neglect that the previous owner put into it is really the issue. So some of the other programs we've talked about is what is going to help keep that from happening moving forward. But that's the category change makes it inaccessible to our biggest category, which is 3, and that's too bad.
Yep. Okay, thanks, Allison. All right, well, I want to keep us on schedule here, so let's go ahead. Is there a motion to approve resolution number 4?
I will move to approve resolution number 4, series 2023, authorizing changes to category 4 to category 5 and new deed restrictions for the lots of the Smuggler Run subdivision. Specifically, I guess I don't need to say that, but in the context of a more permanent structure being added to the property.
Okay, we have a motion from John Ward.
I'll second.
And a second from Ward. And it's a roll call vote.
Okay. Kelly?
I am going to vote no, not because I don't think that there's a lot of merit here. I just think this is not fully cooked, and our debate is important. Thank you.
Ward?
I'm going to vote yes.
Carson?
Yes.
Allison?
For the same reasons, I'll vote no, and I'm hoping that it will pass and wish the best to those owners.
The swing vote.
John Ward?
Yes.
Sorry about that.
All right, motion passes. Okay, and that'll come back for second reading.
No,
Or no, it
well,
won't.
this is
No,
it.
no,
That's
it's,
it. Okay.
it's not a change in the
Sorry.
rules, so it's just,
The broader discussion is going to be the rest of the mobile home park in context to maintenance, whatever else besides just replacing.
And the rest of the program that's
Yep.
Sidewalks.
centennial. There's tons of places that can't afford to.
I'm curious how many category 3 single-family homes are there in the program?
I'd have to look
Yeah,
at
we
it.
can look that up for you more.
I'm not
That's
sure.
a good question.
Well,
There are
category
some.
3, this is a whole philosophy.
Absolutely.
Real world,
The distribution of the
you don't
capital.
get a single-family home unless you can afford it, right? You might buy a condo. There's, how many single-family, category 3 condos do we have
A lot.
A lot,
in
yeah.
the system too? So
Yeah, but in Denver, you can get a single-family home
For 500 grand.
cheaper than a downtown condo that has your
It's not
pool and
cheap in
stuff.
Denver.
you
This
know.
ain't
Yeah,
Denver.
don't be
Same
so
in
sure
Denver.
about
It's not
Denver
just a-
right now.
Can't
They're,
compare it.
they're going through a lot of changes there.
All right, so given that we have a public hearing on appeal on the agenda here, and this board has not had a public hearing on appeal as we sit here today, I've got a executive session on here, so I'm going to go ahead and make a motion for a conference with APCHA attorney for purpose of receiving legal advice under C.R.S. section 24-6-4024B regarding public hearing on appeal of Highlands Villas LLC.
I'll second that.
Okay, and then this is it's a roll call vote.
Okay. John Ward,
Yes.
Allison,
Yes.
Carson,
Yes.
Ward,
Yes.
and Kelly.
Yes. Has Francie joined yet?
No.
No, I'm gonna, when I go out, because we have to leave too, I will try to call her.
For the benefit of the
Okay,
public,
thank you. I've tried to get in touch too. I'm in a tricky spot right now, so thanks.
Thank you, Kelly.
for the benefit of the public, this is just, and the parties, this is just to discuss hearing procedures, because the board hasn't had an appeal hearing before.
Yep.
So,
Thanks, Tom. Okay, so we're going to pause GrassRoots, and if everyone would clear the room here for 15 minutes.
Recording stopped.
And we're gonna need Kelly to call back in. Yeah, Allison, do you wanna have, she's calling in. Okay, great. All right, we're just waiting for a representative from the county commissioners here to get going.
While we're waiting, can I try and set up
Sure.
here, if you don't mind?
Go ahead.
I have not, Ward, I may need your help.
Now, is someone from staff gonna make an initial?
Yes,
You will?
yes.
Okay.
Yeah, I have what
You'll go.
Bethany gave me what she would say.
You'll go first then.
Yeah. Yeah.
Just a brief staff introduction, then Jody, and then you, Marie, okay?
I'd like to make a disclosure that I have done computers for Klein, Cote, Edwards, and Citron for decades, and I don't see a conflict here, but I want to make a public disclosure if there are any objections for me hearing this.
That's a good point too. Jody offices in my building. I see him once in a while, but I don't really talk to him, so.
I wouldn't talk to him either.
You're rude.
Maria, do you have an objection?
And I'll disclose, I've got multiple accounts in John's bank. I've had a beer or two with John Doyle.
Disclosure.
I think we're good, and Kelly I'm good with.
I think it's just a little delayed as well.
We gotta get her on there.
Does anybody know how to use this computer?
Francie, I think
Somebody
is
does.
joining shortly.
Cindy?
I'm sorry?
Do you
Thank
know
you,
how to
Kelly.
help
Do you
Jody
know how to
here?
use this computer? It says guest user, and it's asking me for a password.
It's the county.
It was sitting here. It's a
It's here.
county,
Computer.
it's for presentations.
It's
Yeah.
called,
Can you do yours
It's called the
instead?
speaker laptop, Pitkin County. I've
And
used it
the-
before with the BOCC.
I would think that don't they have sign on someplace?
Was only the Wi-Fi, but not for the
That's
computer.
Wi-Fi.
Yeah, I
This-
don't know how you can get on a computer here.
Can you use yours?
Did you try picking
I don't have a
gas?
clue, so.
Yeah, they don't-
Password's
and nobody's
incorrect.
here. I'm really sorry, I don't, we brought our own computers and stuff, so that's one of the reasons why.
I'll ask.
I don't think there's anybody out there, but
Can those cords just go on his laptop?
he's gonna have to get in our Zoom. He can get into Zoom on that.
But he can't get his stuff from there to there.
Oh.
You might want to sign into Zoom on your own computer, not the county. That's the only way it can allow you to share something.
Okay, did you guys ever figure out what the Zoom password was?
Yeah, it's was never carried over, but it's the same password. It should be working now.
APCHA 0607.
Yeah.
Okay, so how do I find that? Go to the email from you, Cindy?
Here, I got it right here.
The Zoom link?
It's,
The Zoom
Here
link.
comes Francie.
meeting ID is, that's what we meant for.
Do I have a link, though? I need to. Okay, I'll
If you
go.
go to Zoom.
I think Cindy sent me an email the other day that I think may have had it on
It
it.
should have it on there.
Hi Francie, can you hear us yet?
Yeah. Pitkin County cares.
Francie, get that.
There we go.
Hi Francie.
There's Francie.
Can you hear us, Francie? Yes.
Yes.
Welcome, Francie. Okay, so we will go to the next item on the agenda, which is public hearing on Appeal of Highlands Villas LLC from the findings of fact, conclusions of law, and ruling of APCHA hearing officer dated January 20th, 2023. I believe we're going to start here with, we'll have a presentation from staff, and then Highlands Villas, and then MAA. So with that, Cindy, you want to go
Okay.
ahead?
This is just a short statement for, from APCHA, from Bethany Spitz. She worked really closely on this. This case is an appeal by Highlands Villas LLC of APCHA's July 21st, 2022 notice of violation. MAA has a priority given to it by the deed restriction to rent dorm units during June, July, and August. APCHA was notified by MAA during the summer of 2022 that Highlands Villas LLC was requiring,
It's probably me.
can you mute? Was requiring the MAA to lease the dorm units
On your computer.
You can mute
Jody.
on
him.
the computer, I think.
Yep.
Recording in progress.
Boomer.
Can you mute him?
Can we mute that? Can we mute that?
She muted me.
Microphone?
So I show Jody's muted, Karen is not muted, and Francie is not muted.
Ghost in the machine. I'm just happy to know it's not mine.
I wasn't listening to her. What did she say? She said, notified options. Just this one. To rent the units beyond July. She was in the middle of that statement. When in fact they were notified in April prior to the execution of the lease.
Carson, it's you.
Not me, I'm muted.
I hear, no, you need to mute your sound on your laptop.
No.
Your laptop's, okay, making sound, but the speakers on your laptop are making sound. Yeah.
Well, would you like me to
Wow.
just pull
No,
out?
I think we were
'Cause
good.
it-
Did we get
I
it?
think we just got it. I say we.
All right, who's the guilty
I didn't mean we.
Somebody.
I think it was me.
A little bit of everything.
So I'll finish the statement. So APCHA was notified by MAA during the summer of 2022 that Highlands Villas LLC was requiring the MAA to lease the dorm units for some of May and September if MAA wanted the units during June, July, and August. Only so much of that information was available to APCHA. APCHA staff did not have first-hand information. The two parties of interest have first-hand information, MAA and Highlands Villas. APCHA believes we acted in good faith and still believe that the NOV was valid and that the hearing officer agreed to that. When Highlands Villas LLC objected to the NOV, the notice of violation, MAA had the first-hand information. That is why APCHA is not the main party to presenting the main case to the board. All the evidence is in the record, and the board is bound by the record in terms of the facts. And staff believes the hearing officer was correct in his decision.
Okay, Jody, Highlands Villas.
Am I on? Do I need to, which one of these buttons do you want me to hit?
The
Just for speaker.
red means on.
Host?
I did not yet.
I think you're okay.
Can you hear me now?
Yeah.
I think so.
Great.
And you're gonna make me a co-host so I can?
You are?
Okay. I'm gonna have a PowerPoint presentation, which I have discussed with Tom, and I don't know whether I mentioned it to Maria or not.
State your name, please.
I will. For the record, my name is Jody Edwards. And I represent Highlands Villas LLC. I am about to share a PowerPoint presentation which has no new evidence in it. It's my argument. So that is, I want to just be very clear about that. Okay, how do I do this? Boom.
There we go. You're doing it.
You got it?
Yep.
Great. All right. So for the record, my name is Jody Edwards. I represent Highlands Villas LLC. I will submit a hard copy of this PowerPoint presentation,
I'll
both.
pass them out for you.
Great. Thank you. With me today are Kevin Joseph.
Can I really haven't seen this before.
Why don't you take a look? Before you proceed, Jody, why don't
Okay,
you see
that's
if
fine.
Maria has an objection?
With me, while Maria's skimming through this, with me today are Kevin Joseph, who's right here. He is a member of Highlands Villas LLC, and John Keneally is assisting me. He's an attorney in my office. Why we are here is that we are appealing the findings of fact, conclusions of law, and ruling provided by the hearing officer, Michael C. Ireland, dated January 20, 2023. For simplicity, I'm going to refer to that as the decision. Okay, and this first slide is really just sort of background stuff.
Can we
Yep.
wait while we can confer about this?
Sure.
'Cause I definitely
Sure.
did not see this.
And could you state your
This
name,
is
please?
Maria Morrow.
Yeah, sorry, Maria Morrow. I'm the attorney for MAA. Did I say that too fast?
This is just
I
my
have the
argument.
spelling
This is
wrong.
not, well, whatever.
I have this one.
So do I need to pause while, Tom, do you want me to pause?
Why don't you wait for a second, Jody?
Yep, that's fine.
All right, so we'll just,
Here come the judge.
Maria says on the APCHA board, if we're disclosing things. Sorry about that.
This is just a summary of information that was presented to us in the packet.
That's what he says.
I think she's gonna argue that.
That's what I'm saying. She says something else, and you're entitled to hear both arguments.
Maybe you can just use it as a
Judy, you
script.
can come
if
up
you
with
don't.
some better, is that part of it?
I am not an artist. It was black and white to start with, so, you know, at least we added some color.
And Karen, I have a misspelling of all these.
Hearing.
It was most of our meetings, actually. That was most, once a month, probably. Most of them were pretty cut and dried. I mean, most of them were violations and,
So the ones that were not, that were awful.
Yeah.
but I don't think there was one that wasn't. I mean, there was just some heart, there's one lady that she rented a room out, or she, you know, she didn't have a job, but she needed to.
So, just for the.
We back on the record?
So, Tom and I have discussed this. This document wasn't disclosed to me prior to the hearing. I want to make sure that we're able to facilitate this hearing today. Everyone wants this over. But I'm going to register an objection because if there is new evidence that comes through, and if the board should not consider it. And it's prejudicial to me to provide 20 pages of something at the end of the day that might have additional information in it. I don't want to stop him from doing it. This is the presentation he's prepared, but I'm just going to register a standing objection that you must decide based upon the record and not upon what he's typed up here today, okay?
Will you point out if you feel there's new evidence being presented in this?
Yes, I will.
Thank you.
I don't believe there is, but
Let's just go ahead and
we'll see how it goes.
Yeah.
All right, I'll start over, if that's okay. For the record, my name is Jody Edwards, and I represent Highlands Villas LLC, the appellant. We're appealing the findings of fact, conclusions of law, and ruling provided by the hearing officer, Michael C. Ireland, dated January 20, 2023. For simplicity, I'll refer to that as the decision. With me today here are Kevin Joseph, who is a local business owner and member of Highlands Villas, and John Keneally, who is an attorney in my office. So slide 1 here in front of you, it's very quick. I'm not going to spend a lot of time here. This is a sort of some of the factual background about this dispute. All of this is in the record. Most of it even cites to the record. Highlands Villas closed the purchase of these units in January 2022. There's, by the way, there's 6 different dorm-style units. The deed restriction, which is Exhibit 4 in your record, states, quote, "These units may be occupied by Music Associates of Aspen, MAA, music students and/or faculty in the summer months of June, July, and August, and winter seasonal employees from October through April." So what happened was 2 months after closing on the purchase of the units, MAA reached out to Highlands Villas and said that MAA was going to lease the units for the summer in accordance with the deed restriction and requested to rent the units from May 15 to September 1st. That's in your packet at page 237 if you want to look at it. That sort of kicked off what ended up being the negotiations, which are in your record at Exhibits 12, 14 through 22, 27 through 40. And you'll see that what happened was a series of back and forth email conversations that went on from March 29 to April 27, 2022. So whatever that is, 29 days, something like that, a month, we'll just call it. During the record exhibits show that MAA regularly sought advice from APCHA during those negotiations. APCHA was aware.
I'm going to object to this one. I actually don't think there was any evidence in the record about whether APCHA contacted Highlands Villas or opinions about it. I don't think the appellant put on any evidence about that. So
APCHA did not contact Highlands Villas, and that's not what I said.
That's new evidence. An attempt to enter new evidence.
I believe that in the record there is communication from MAA to APCHA.
And that's what I said.
That's correct.
I thought that's all he was referring to.
Yeah, he has 2 points here, that we communicated regularly with APCHA during the negotiations, which we passed on. But he also accuses APCHA of making no effort to opine whether the lease was violated.
Okay. That's a matter of opinion. I don't think it's a problem. You can disagree.
And next item is the lease. Record Exhibit 6. The lease was signed and delivered by both parties. That is an agreement between MAA and Highlands Villas. It has a term from May 5, 2022 through September 25, 2022. Am I good? I don't even know where I am. So, but kind of the important thing to see on this slide is there are 2 different documents. There's this deed restriction, which was executed sometime in the 90s, and that's your Record Exhibit 4. It is an agreement between APCHA and Highlands Villas. The second document is this lease. Lease was signed and delivered by both parties. It had a term of May 5 through September 25, 2022. That's Exhibit 6. That is an agreement between Highlands Villas and MAA. All right. Sort of the important thing that you are here to do today, and I'm going to go through this real quickly. We're not supposed to enter any new evidence, which is what the first thing there says. Second thing says that what your job is to affirm, modify, or reverse the hearing officer, or determine if if you need additional evidence. I kind of doubt that's the case. We've got 666 pages of evidence. But the standard of review, and I don't know whether Tom went over this with you in your executive session or not, but you're supposed to figure out whether or not the lower tribunal, that is the hearing officer, abused his discretion or exceeded his jurisdiction. And you'll hear me use those words a fair bit today. I'll show you that it is crystal clear that the hearing officer both abused his discretion and exceeded his jurisdiction. So I'm going to need to talk about both of those, and this is just law. This is not evidence. And I'll be as quick as I can. So abuse of discretion. In considering whether there has been an abuse of discretion, courts may consider whether the hearing officer misconstrued the law. Abuse of discretion means the decision under review is not reasonably supported by any competent record. So kind of putting that in English, abuse of discretion is wrong law or no evidence to support the findings. Either one of those. And I'm going to show you that both occurred in this case. The wrong law was used for what the legal standard for what is required for duress, and there was a finding in the decision that there was no reasonable alternative that was not supported by the evidence in the record. So we're going to find both of those. The other thing that you're supposed to be reviewing is whether or not the hearing officer exceeded his jurisdiction. Jurisdiction means the right, power, or authority to interpret and apply the law. In this case, if you look at Part 6, Roman 6, Section 5 of the APCHA regulations, what you find is that the jurisdiction of APCHA, and in particular the hearing officer, is the power to enforce the deed restriction. Now remember, I said there's two different contracts here. There's the deed restriction and there's the lease. The hearing officer has the power to enforce the deed restriction. Now, I'll go through this next part really quick. There's a doctrine in the law called the sanctity of contracts, and in fact, it's even in our Constitution, Article 1, Section 10, Clause 1. And basically what it says is that contracts are important. Without a contract, society doesn't function. You can't have an economy that functions without contracts. Contracts are how, when you and I make an agreement, I know you're going to uphold your end of the bargain, and you know I'm going to uphold my end of the bargain. There are exceptions. If we make a contract on an illegal subject matter, a contract with a minor, fraud, forgery, those are all exceptions. And in all those cases, the courts will set aside a contract. What's going on here is that MAA is asserting that it executed the lease, that contract, under duress, actually a type of duress called economic duress. Now, what you need to know about each of those exceptions to the doctrine of sanctity of contracts is that they are extreme situations. It's a very high bar. You don't courts don't set aside a contract blithely. You gotta hit that high standard in order to set aside a contract. So the question becomes, under what circumstances are the courts going to set aside a signed contract based on economic duress? And the judges get to determine what the law is, and the hearing officer, and the hearing officer applies the law. So economic duress. A contract is voidable on the grounds of duress if a party's manifestation of assent is induced by an improper threat that leaves no reasonable alternative. To establish duress as grounds for avoidance of a contract, conveyance, or other act, it is not alone sufficient to show the exertion of pressure by threats or even physical compulsion, but it must also clearly appear that the force or threats employed actually subjugated the mind and will of the person against whom they were directed and were thus the sole and efficient cause of the action they took. In other words, they signed the lease because somebody had a gun pointed at their kid's head. I mean, it's got to be the threat must clearly appear to subjugate the mind and the will of the person against whom it's directed, such that that was the sole and efficient cause of the action he took. And the figurative, the thing you see in all the movies, and is the mobster holding the gun to the kid's head, making the parents sign the document, whatever it may be. So in this case, if you look on the right side of the screen, the elements of duress, there are three of them. Improper threat. The threat actually subjugated the mind and the will of the person against whom it was directed such that the threat was the sole and efficient cause of signing the contract. And three, no reasonable alternative. In this case, the threat is discussed on page 9 of the decision of the hearing officer. He said, quote, Highlands Villas simply told MAA they could sign the lease or drop out. That's in your packet at page 560. On page 10 of the decision, the hearing officer states, quote, in this case, the threat was to drop MAA from any lease or not allow MAA to lease for only 3 months. That's in your packet at page 561. So assuming the offer to drop out is a threat, and I'm not going to argue about whether or not that's a threat, the question under the law is whether that threat actually subjugated the mind and the will of the person against whom it was directed, such that the threat was the sole and efficient cause of signing that lease. On your screen now is the legal standard as determined by the hearing officer. On page 7 of his decision, he says, quote, hearing officer finds that proving that the duress is the sole and efficient cause of subjugation of the mind and the will is not required. So let's go back. Colorado Supreme Court, Colorado Court of Appeals, Colorado Federal District Court all say it must clearly appear that the force or threats employed actually subjugated the mind and the will of the person against whom they were directed and were thus the sole and efficient cause of the action he took. Hearing officer, it is not required. That was his first error. That is an abuse of discretion. He applied the wrong legal standard. I'm going to talk about 2 more errors. The next one is, well, there's a whole bunch of evidence to the contrary here, and I'm not going to go over that. But when you get into your deliberations, whoops, I just went way too far. When you get into your deliberations, you can look back at that slide 8. But the second abuse of discretion has to do with whether or not there were reasonable alternatives. And that is also an abuse of discretion. So in your packet at page 50, 560, you will find that the hearing officer acknowledges that there can be no duress when reasonable alternatives exist, but then he makes a finding that no reasonable alternatives existed. So in this case, there were reasonable alternatives. The courts have held that consulting an attorney, opportunity to get an injunction, objecting to signing an offered lease, or even reporting to violation, and that hadn't been held by a court yet, but even reporting a violation to APCHA is a reasonable alternative in this case. Now remember, you don't set aside contracts lightly. You have to show that this really was duress. So, I'm way off. Consulting an attorney is considered by the courts a reasonable alternative, and the hearing officer recognized that. I've quoted from his decision there on the left side of your screen, and I've highlighted certain provisions that relate to consulting an attorney. So it's the opportunity to consult an attorney, could have consulted an attorney, or discuss the matter with a lawyer. In all those, and there's citations right there on your screen to the case law, in all those cases, they held there was no duress because there was an opportunity to consult, could have consulted and discussed the matter with a lawyer. So those things prevent the use of duress as a means of setting aside a contract. So on the right side of your screen is some of the testimony that we heard at the hearing. And I'm going to read this. Question, but did you engage an attorney prior to executing the lease? Answer, yes. Question, who did you engage? Answer, I did speak to one, someone who works with Maria. Question, okay, and when was that? Answer, I'm sorry, it was within a period of time of, the 20th to the, it was within that period of time where I felt like I was crunched and had very little time. So, question, so prior to your execution of the lease, you spoke to an attorney? Answer, yes. So again, that's in the hearing transcript, which is in your record. In fact, MAA did consult with and engage an attorney. It was someone in Maria's office. Maria, there's also in your transcript, it says Maria was out of town. So what happened here was that in an effort to reach the desired result, and again, ignoring the law, the hearing officer invented a new standard. And that's at the bottom left of the screen. He decided that the key was an opportunity for meaningful representation. Now, that's not what the courts say. Courts say you only have to have an opportunity to consult. You don't have to actually consult. He said you have to have meaningful representation. Two totally different standards. The hearing officer then found that MAA was, since they were unable to reach their usual attorney, Ms. Morrow, they didn't have meaningful representation. That's in the decision. There are several very good lawyers in Ms. Morrow's office. I can attest to that. I'm sure she can too. The law does not say anything about consulting with your the lawyer you have used historically. It says you just have to have an opportunity to consult a lawyer. If you do, that's a reasonable alternative, and duress doesn't fly. All right, the third place where the hearing officer went out of bounds was he exceeded his jurisdiction. The jurisdiction of the hearing officer is limited to the question of whether or not there was a violation of the deed restriction. The units, the 6 units at Highlands Villas, were in fact rented to MAA pursuant to the lease the months of June, July, and August of 2022. There was no violation of the deed restriction. The hearing officer has no jurisdiction of the lease, over the lease. Matter of fact, if you go read the APCHA regulations, there's really no jurisdiction over a private party-owned lease. What APCHA is entitled to do under the regulations is go take a look at the lease, and for example, if the deed restriction says a Category 2 occupant, APCHA can confirm it's a Category 2 occupant. If it says Category 2 rental rate, it can confirm Category 2 rental rate. If it says there's a 6-month term, APCHA can do that. But APCHA doesn't enforce the lease. APCHA's jurisdiction is on the deed restriction. And the only way you get to the lease is making sure it complies with the deed restriction. Well, in this case, the hearing officer went way out of bounds because what he did, you can see there on the bottom of the screen, on pages 2 and 16 of the decision, which is in your record, he held that the lease was, at least in part, void. He doesn't have the legal authority to declare the lease void. What he has the legal authority to do is determine whether or not there was a breach of the deed restriction. So if here's the key, you got to understand this. In this case, if MAA believes there's a problem under the lease or that it's unenforceable because of it, there was economic duress, then the appropriate remedy for MAA is to go over there to the courthouse and talk to the judge about whether or not there was economic duress. Then they can get a court-ordered declaration that the lease was void or that MAA is entitled to some rebate of rent. MAA didn't do that. Instead, they came to APCHA. Now, if you look at the documents in the record, the reason for this becomes kind of obvious. The lease, which we've already talked about, is an agreement between MAA and Highlands Villas. The lease says that in the event we go over here to the court and we have a discussion about whether or not there was economic duress and Highlands Villas wins, then MAA has to pay our attorney's fees. If you go look at the deed restriction, also in your record, what the deed restriction says is that if after this hearing we end up in the court over there, APCHA has to pay Highlands Villas attorney's fees, not MAA, APCHA, because APCHA is the party to the deed restriction. So what MAA has done here is they've transferred all of the risk from MAA over to APCHA by using the wrong forum. Instead of going to the courthouse where they should have gone to object to a lease issue, they've gone to APCHA, to the hearing officer, to have him take a look at whether or not there was a breach of the lease, but his jurisdiction has to do with the deed restriction. There's probably a second reason why APCHA chose this forum as opposed to the courthouse. If you go to the court, you're going to get an impartial judge. And here, they knew who they were getting as their hearing officer, who's very well known in this community as being, looking at a result, not the law. So, in conclusion, the decision should be reversed because the hearing officer abused his discretion and exceeded his jurisdiction. He abused his discretion because he applied the wrong legal standard. He, quite honestly, invented a legal standard. He ignored the facts in the record regarding reasonable alternatives. The courts have made it very clear that if you have an opportunity to consult an attorney, that's enough to defeat duress. He made up a new standard and ignored the testimony in the record that APCHA, in fact, engaged and spoke with an attorney. And then, lastly, he exceeded his jurisdiction because there was no violation of the deed restriction. In fact, the units were rented June, July, and August to MAA students. And he went above and beyond his jurisdiction to try to declare the lease void. There's one last thing I need to talk about. I have focused on the law here today. The law, the law inexorably leads to the conclusion that the decision must be overruled. Some of you might not like that. Some of you might want a different result. The hearing officer clearly wanted a different result, and he twisted himself into a pretzel to get there. He ignored the law and he ignored the evidence so that he could get to the result he wanted to get to. The rule of law is a principle that all people, all institutions are subject to and accountable to, and it should be fairly applied and enforced. It's the foundation of any democratic society that respects human rights and freedoms. It ensures that everyone is equal before the law and no one is above the law. Therefore, I urge you to respect and uphold the rule of law even when it's hard, even when it's inconvenient. In this case, that means you must reverse the decision of the hearing officer by making findings of fact and conclusions of law, holding that he abused his discretion and exceeded his jurisdiction. Thank you, and I will be available for any questions.
Thank you, Jody. Are there any questions for Jody and Highlands Villas?
As an alternate?
Sure.
I guess, just curious, this is about overpayment of rent. How much money are we talking about?
It's in the ruling.
Yeah, I want to say
48,000.
48,000.
So ultimately, the amount of the lease, adding all of the extra weeks, about 6 extra weeks, cost MA $48,000 that it would
Significant.
otherwise had to pay. Yeah.
Thank you.
Yeah.
It's about payment of rent for May and September. They're not objecting to the payment of rent for June, July, and August.
Exactly.
For 6 units. But wait a minute, it was 30 days.
No,
They wanted to rent it May 15th.
40 days.
They
40 days, yes, sorry.
Well, what'd you let?
Yeah.
We gotta stick to the
Okay.
record. When we let.
Yeah, I pointed out in the record, the very first email from MAA opened the door to different dates. They offered, the very first email offered May 15th through September 1st. That's the start of the negotiations. It ended up a little wider, May, whatever it is, it's in that first page.
Thank you.
May 5th, September 25th, yes. But nobody has asserted that and I'm not sure if this is what you were asking, if the rent was in excess of the rent allowed in the guidelines. That's never been asserted and is not in the record anywhere.
Not at all.
Okay.
Can I ask a couple of questions?
Yeah, go ahead,
On the
Tom.
chronology, and you can comment if you think he's got it. No.
You want to sit?
No.
You want to come up?
No, please.
Oh.
You can correct, if you want to correct what he tells me when it's your turn, you can do that. I'm just interested in the chronology, some of the chronology to make sure we have that clear from the record.
Okay.
The lease was written by Highlands Villas and transmitted to the MAA, correct?
The one that was ultimately signed, yes. There, if you look at that email that I referenced in the beginning, the March 29th email, MAA actually sent us a lease that was from the prior year where they said, here's the one we used before.
Right, okay. So you sent, Highlands Villas sent the lease to the MAA, and the date of that was April 17th, is that correct?
I don't know the exact date, but that sounds right. Does anybody?
No, you gotta just do this, okay?
Sorry.
Just like, it's just pretend it's the Court of Appeals. I'm sorry, Your Honor, I don't know the answer to that
I'm
question.
sorry, Your Honor, I don't know the exact answer to that question, but it sounds very close.
Even though I'm not Your Honor, I'm not Your Honor. Disclaimer here, that's Your Honor if it comes to it up there. Okay, so it was transmitted the 17th, and it was signed on the 27th, if I read the record correctly?
It was signed by Music Associates of Aspen on the 27th. It was signed by Kevin, who's sitting behind me, a few days later.
So it was signed by the MAA on that date.
Francie, do you have a question?
Yes, can you hear me?
Yes.
If we were to find that Mick either exceeded his authority or used the wrong law, and so his decision is overturned, then what?
You were asking about the process?
Yes, what would happen next if that were the case?
Then it depends. If the losing party on the decision by this board, the losing party is entitled to appeal to the district court within 28 days of the date of the decision, which will be in writing, findings of fact, conclusions of law, and a resolution to be approved by this board, not today, at some future date.
Okay, thanks, Tom.
Any other questions?
So just for clarification, that means that if it's overturned, APCHA or MAA could appeal? APCHA's not involved, it's just MAA?
APCHA has an interest, well, it's probably not an issue we need to dwell on now, but APCHA has an interest in the outcome in terms of enforcing its deed restrictions, so it would have the option of deciding to be a party to an appeal or not being a party to an appeal.
The two parties here are Highlands Villas LLC and MAA.
They're the two primary parties in interest, but APCHA is also a party in interest because this is a beneficiary of the deed restriction that affects the property.
It's actually a party to the deed restriction.
Party, I'm sorry, well, I said beneficiary, we're
Yeah.
a party. So just as in the prior litigation that's referred to in these documents, that was, there were three parties in that litigation: the Housing Authority, the MAA, and Highlands Villa's predecessor in interest, which was the Meyerstein Trust. So it could be potentially the same scenario to litigate this interpretation of the deed restriction.
So were the terms of the lease that MAA sent to you or sent to Highlands? I'm muted because I breathe too loud. So terms of the lease that MAA sent to Highlands Villas to initiate the discussion or conversation, what were the terms previous years? Was it May to May, or was it May 15th to end of September? Was
If it's in the record.
If it's not in our packet.
Yeah, if it's in the record. I
If it's
didn't see
in the
that.
record. I don't know if it is.
Okay.
I don't think that lease is in the record. I think only the transmittal email is in the record.
I'm just
But
trying to get back to like history of
In
previous years.
in that email, it says it was the lease from the prior year. But I
Okay.
don't believe, and Maria will correct me if I'm wrong, that that lease is actually in the record.
Okay, sorry.
Any other questions?
So I'm clear on this, that In question is the term of the lease from June 1st, or from May 5th to June 1st, and from August 31st to September 25th.
When you say in question, sort of, yes. The assertion by MAA, their argument has been that they only signed that lease as a result of economic duress, and that but for economic duress, they wouldn't have signed a lease that had that time period in it.
And the economic duress is rent for that period? Economic duress is for that period of time that exceeds the June, July, and August on
But
both
that's
ends.
not what's in the record.
Can we, we can't really have this discussion.
Why don't you ask Maria what the basis for her case is, and we'll go from there.
Okay. Francie, did you have anything else? Sorry.
Yes, I do have one more question, if that's okay with you
Go ahead.
guys. So can the duress come from a situation other than the opposing party?
I'm sorry, can you repeat that?
Can you repeat that?
So my question is, can the duress actually come from anything other than the opposing party here? So, I mean,
That's a moot point because the duress is claimed to have been imposed by Highlands Villas, so no other party matters.
well, I was thinking not so much of a party as the situation that there was no other housing in the valley.
Franz, can we confer with our lawyer post-presentation and deliberate as a full board?
Sure.
Following that, thank you.
I think to clarify, deliberations would not be an executive session, only legal advice.
Following that, yeah.
Yes,
Right.
right.
I just don't want to,
The board does need to deliberate in public
Right.
before making a decision. Yes.
Okay. If there are no further questions for Highlands Villas, we'll have MAA come on up.
Thank you.
Thank you, Jody.
Thanks, Jody.
So this is working and you can all hear me? Okay, and if anyone who's on Zoom can't hear me, is there a way for them to signal? I was just,
I'm assuming that.
I'm not,
Francie,
I'm a
Francie,
paper
can you hear?
person, so.
I think you're okay. She'll tell us if she's on.
I can
And
hear.
Thank you.
Great, thank you.
Don't forget your name and representation.
Got it. My name's Maria Morrow. I represent the Music Associates of Aspen, which we know as the Aspen Music Festival and School. With me today is Jenny Elliott, who is one of the longtime, I really think she's #1 at the music festival, but I suppose probably Alan would appreciate it if I said she wasn't. She was #2. But her official title is Senior Vice President of Strategy and Administration. And she's been familiar with the deed restriction at issue for many years in her tenure at the Music Associates of Aspen. These deed restrictions went into effect decades ago when Aspen Highlands was developed, and it was part of the developer's concession that there would be built dorm units to house the music students during the summer and to be available to Aspen Ski Company employees during the winter. Before I go into some of it, I want to answer a question that Mr. Ward asked, because it gives you some sense of what's in the record as to the history of the deed restriction. If you go to the transcript at page 19, you'll see that Ms. Elliott testified as to the history of the deed restriction. And what they would do every year is they would email the owner of Highlands Villas and say, hey, we're going to exercise our option as to X number of units for the months of June, July, and August. After that exercise would happen, APCHA and the parties would determine what the price would be based upon certain escalators and utilities that would go into it so that it would be affordable housing. It is supposed to be price capped, the price is controlled. And obviously, when you add weeks on, you start messing around with the price. If you add weeks somebody doesn't need, all of a sudden, The price is not capped. But that was what the tradition was. And if you look at page 19, they said that Milton, who was the prior owner, would send MAA a lease. The price is determined by APCHA. This is Ms. Elliott speaking. Our units are actually a special category within the APCHA framework to set that price. And then on top of that, they can add utilities and some other things. I don't know the details or all the things they're allowed on top of the rent. So the rent is not determined by the owner or MAA. APCHA decides what the rent will be. Correct. And what is the period of time? What is your understanding of the period of time for which MAA holds an option? The months of June, July, and August. And if MAA wanted units for additional periods, does it have the right? Ms. Elliott, we could request. I would assume if I wanted to rent them for longer, I could ask. There's nothing that says they have to give them to me, but I could ask. I asked her, and all the time that MAA has exercised the option, has it ever asked for May, September units for the students? Answer, never. Why? Well, the students don't arrive till mid to late June, and they're gone before the 1st of September. You'll also see that there were communications in the record where we told the owner that the units would sit empty for May and September. We didn't want them, we didn't need them, they would be empty. So there was really no dispute that MEA didn't want the units for May and September. In the record, so let's talk about, that was to answer your question, and now maybe I'll go through the presentation, but certainly stop me if you want me to sidetrack. So the deed restriction here is incredibly simple. It is the first part of, if it's, let's see, I think it's in your record at 221. I don't know if you have it in front of you, but it is probably 12, 15-page restriction, but there are only 1 or 2 sentences that deal with MAA's rights at all. Everything else has to do with some other aspect of the deed restriction. And this is all it says about MAA. These units may be occupied by Music Associates of Aspen, MAA music students and/or faculty in the summer months of June, July, and August, and winter seasonal employees from October through April. The seasonal beds will be occupied in the off-season months of May and September as demand warrants. That's it. 2 sentences. There's no requirement that MAA sign a lease whatsoever, actually. So this is about a violation of the deed restriction. MAA was, when you look at these 2 sentences, one of the things that happened previously, and you referred to it, was the Meyerstein litigation. MAA was embroiled in several years of litigation with APCHA and the prior owner back in the year 2008 because the attorneys for the prior owner, Meyerstein, decided to challenge these 2 sentences. And their argument was, well, may be occupied by MAA. It's not mandatory. We're not required to provide it to you. And the parties litigated for years at great expense to APCHA, its staff, and MAA to try to decide if that's what that 1 sentence meant. Ultimately, I think it went up to the Colorado Supreme Court, right?
Colorado Court of Appeals.
Court of Appeals?
Not to the Supreme.
Okay, the Colorado Court of Appeals said that...
Twice.
How many years was it?
I don't remember. 4 or 5 years.
4 or 5 years. The decision was, May is mandatory. This is an option. It is a unilateral option for the music festival, and they're allowed to occupy the units in June, July, and August if they want them. That is as simple as it is. And when you think about these 2 sentences and the years of litigation we've already had and the year we've been through, you have to wonder how many times attorneys can twist and turn this language and try to pretend it means something different. What it means is MAA has an option, and if it wants the units in June, July, and August, it gets them. It doesn't have to sign a lease. There's nothing in the deed restriction. Jody, none of his slides had anything that said that we had to sign a lease whatsoever. They should have given them to us. I hope this is the last time that attorneys litigate these 2 sentences, and I hope that we're nearly done. And so we're here again fighting over these few sentences, and I appreciate your service and the attention you've put into this. I hope that we are never back here again. I have provided for you, attached to my brief, a few facts because I want to give you a flavor of what those emails said and what Mr. Ireland was looking at. I think it's very easy for people in the community to accuse him of, having an agenda, but he's a lawyer. He's ultimately an officer of the law, and I don't give any credence to that. He either got the law right, which the APCHA staff agrees, and so do I, or he didn't. But he sat through, after his surgery, hours and hours of testimony and read 700 pages of documents. He read all of this law, and he analyzed the law for you. He did not make a mistake. Let's look at just a few of the things. I'm not going to drag you through the hours that we spent in the hearing room. But if you look in your record at page 30, you will see there are two exhibits that I've provided for you, and they are in your record at 28 and 30. And I want to start with how MAA delivered the lease. MAA delivered the lease on April 27th. This is less than 30 days before the students have arrived. Faculty is already arriving. The testimony in the record was that this was a very tight housing market. Other people were out looking. MAA had been looking for a long time for housing and didn't have it, and that it had to have these units. When MAA signed the lease, the cover letter says it's being signed under protest. It says, as I mentioned to Amalia, who was the owner's representative, the question of whether our right of first refusal for summer months can lead to a requirement that we rent in May and September was an issue that was dealt with in the 2008 lawsuit. Due to the time constraints, I want to get the lease signed for you as a commitment to our rental this summer. This is not an acknowledgement that we agree that the extended lease term is appropriate for the lease restrictions. We look forward to further discussions with you on this topic. So this lease was signed under protest, knowing that there would be further discussions between APCHA, and perhaps at that point Mr. Smith would be able to get involved, but that they did not have the right to force us to sign a lease for that long, and that the discussions would have to continue. There's nothing more classic of an economic duress than signing a contract under protest and saying you don't have the right to make me do this. The case law that Mr. Ireland relied upon and under duress, there's a couple different types of duress. The one that Jody used an example of was a mobster holding a gun to a child's head somewhere, which is definitely not at all what is at issue here. And Mr. Ireland was correct that we didn't have to prove that we had a gun to our head. I'll go through the law on that later, but then let's also go through the email string to give you a flavor of how it went during the month or so that there were conversations, which Mr. Edwards loves to call them negotiations. Mr. Ireland said there were no negotiations. We made a small concession at the beginning that we would rent a little bit in May in order to make nice with the new owner, and that the owner did not agree. And I will read you the email string that happened right off the bat. So this is all, if you want to look in your record, it's on page 30 in the record. And if you go, you got to read the email strings backwards. On March 29th, so there had been a prior discussion. The testimony in the hearing was that at some point in March, a staff member at MAA had contacted the owner and said, we want to exercise for the summer, June, July, and August. And they said, we'd really like you to take some in May. And there was a discussion, and we made a business decision that we would rent for May 15th to September 1. So on March 29th, there's an option exercise that says, I'm writing to confirm that AMF will lease the 6 units in Building 4, the units are listed, from May 15th to September 22nd. An example of our lease from 2019 is attached. That was sent March 29th at 9:43. Less than 2 hours later, MAA got an email back from the owner saying the lease will be from May 5th to September 25th. That wasn't a negotiation. That was a demand. That was similar to the demand they had made before, and it was 2 hours later. It says, as you know, there's an unprecedented housing shortage. There's also been an inflation in many costs, right? So they wanted to get more costs back and more money, including HOA dues. We cannot have the unit be vacant for 45 days. We'll leave a 5-day gap on each end as a courtesy. Remember that the Court of Appeals held that this is a unilateral option that MAA may exercise, and there's no requirement of a lease in the deed restriction. So then Ms. Elliott gets involved, and the next day, she wrote to them to try to move this along quickly and try to avoid disputes and avoid what is happening here in terms of the waste of resources. She said, Jalen forwarded your email to me as I have the most history with this lease relationship. I totally agree with the unprecedented housing shortage. Unfortunately, we'll only contribute to it if we lease the units for a longer period of time, as they'll just sit empty. We will not have students or staff in town during the extended period. There is no dispute anywhere that MAA did not need them in May, that the money would be wasted on their part. If they wanted to rent them and make money off of them and they believed they were rentable, they could have rented them out of the market for May and September rather than trying to force it upon MAA. She says, indeed, most of the units will not be occupied until late June. There's further correspondence in the same exhibit in which we send them the deed restriction, and the deed restriction says June, July, and August. Nothing about MAA being required to take it in May and September. They were mailed the Court of Appeals decision, which said it was their unilateral option, and all of the evidence in the record is that they just said, well, yeah, we don't agree. And you can sign it or you can drop out. Here is a direct quote from the owner's agent. Oh, well, thank you for this, referring to the deed restriction. I've seen the deed restriction before, and nothing specified that the lease has to be only June, July, and August. The summer leases in Aspen are longer than that. So basically, it has been their position all along that they can just require a May and September lease, even though there's nothing in the deed restriction that allows them to force us to do that. Then, so the only lease that was exchanged for this summer was the lease that they sent to us, and that was sent on April 17th. This was a question you asked, Tom. Representatives of the owner sent the lease on April 17th. And they say, here's the lease, the 22 lease for the 6 units with 5 beds for you to sign. There's a potential to add more beds. And that lease was May 5th to September 15th, all of that extra time that we did not want. The owner never changed it. They never gave us the lease for the time we requested. They never gave us the lease for the amount of time that's set in the deed restriction. They sent us the lease and said, here it is. There was no negotiation because they never made any concession. They said, we don't agree. We believe we can lease for the longer period of time. And that prompted us then, when our backs were against the wall, to sign the lease on April 27th. What everyone knew, we were running against the wall because we were at the end of April, right? So the timing of what was happening here in terms of the rights is important. The owner wanted to rent it for May, and MAA had no use for it, and we were at the end of April. And so the document that's at the record at 28 is from the owner's representative, and it says, if the proposed dates, May through September, is too long for MAA, we could make an exception and let you drop out for renting. That was the only response. And they knew that other people were looking. They wanted to run it in May, and that was an economic threat, right? When you look at the case law that was presented and what the Colorado Supreme Court has said is, there's more to duress than holding a gun to a child's head or having a gangster somewhere with a weapon or someone pulling their arm behind your back. Economic duress occurs when you have a contractual right to one thing and the person says, hey, you know what, I'm not going to give it to you unless you pay me an extra $48,000. Those are some of the examples that your hearing officer cites. They're cited in the restatement second, and they're cited by the Colorado Supreme Court. So let's say you have a contract to buy a car for $25,000. You sign the contract, you give the person the money, and then they say, you know what, I got to put a little work into the car. The delivery cost me more than I thought. I'm not going to give you the car unless you pay me an extra $48,000. That's duress, right? If you sign a contract to pay the extra amount of money, the court doesn't have to honor it. And under the deed restriction, you know, they want to play a shell game about the deed restriction or the lease. The lease wasn't even required. The answer is they could not charge $48,000 extra for a time period that we didn't use the units, didn't want them, and told them we didn't want them. It was a violation of the deed restriction. There's also just after here at about 41, if you'd like to peruse it, I've pulled out certain sections of the transcript. Jody throws around the word negotiation over and over and over again, but the hearing officer, that is a question of fact, and the hearing officer read every one of those emails, asked questions, cross-examined Miss Elliott, and found there had never been a counteroffer by the owner. A negotiation is, I give you something, you give me something, I don't have to give it to you, you give it to me, there's horse trading, right? That's negotiating. Duress is, well, I have a contractual obligation to give you something, but I won't give it to you unless you give me something else that you aren't really required to do under the contract. That was the ultimate legal difference, and ultimately, the hearing officer was correct. That was duress. They had an obligation to just say, okay, here's the lease for the days you want it. It's unilateral, it was an option, it's our option, it's not theirs, it is price capped. So he was correct that that was a violation of the deed restriction that ultimately led us to have to pay $48,000 more. So the two things that Mick was looking at was whether there was a threat of economic harm. And he looked at the law and the restatement second and the Colorado Supreme Court and said, yeah, if you withhold something someone's contractually obligated and force them to pay you something else when there's time constraints and other pressures, and you sign it because you were under that pressure, if you have no reasonable alternative, then I can set aside that contract. I don't have to honor the commitments that are in there. He cited a number of factors that were in the record. It was a very tight market. Ms. Elliott testified and was examined by 3 different persons about what the market was like, how long they had tried to find units, what kind of incentives they had offered the community to try to get them, that she was aware that there were other entities out there looking for big blocks of rooms and that they weren't available. She testified as to the economic harm that would happen if she had to, at the very last minute, tell 65 students they had nowhere to live. Right? There was economic harm to them. This is real property. When real property is not delivered the way it's supposed to be, that is a really bad contract problem. Jody talks about the seriousness of contract problems. There's nothing greater than not delivering real estate that someone is entitled to because it's irreplaceable. There's nothing more irreplaceable in this community on housing than affordable, price-capped APCHA housing. So Mr. Ireland properly found that under all of the factors, there were no reasonable alternatives. He questioned her at length about her efforts to find substituted places. Mr. Edwards would criticize Ms. Elliott for not filing suit or for not bringing to APCHA the notice of violation at the time on April 27th. Mr. Ireland disposed of that summarily and properly, saying there was not time to do that. That was April 27th. The students were going to be arriving. The units had to be occupied in June. These students were booked. There is not time to get an injunction. There was not time to do a notice of violation. It has taken us a year to get to this point. So he found that was not an adequate way for us to preserve our rights. There's also, if you look in the hearing officer's decision, he talks a lot about, Ms. Elliott was running around trying to do everything she could to smooth things out with the owner and get these units secured. She contacted Ms. Christensen and then Ms. Schmitz. She tried to contact Tom Smith. And we attorneys are not always available when people need them. This is APCHA's deed restriction, and we're not a party. And so she located the Court of Appeals opinion. She located the deed restriction. She located the resolution. She sent them on. APCHA weighed in and said, they're not allowed to force additional time on you. So she did everything she could in her power, but the hearing officer decided it wasn't a reasonable alternative to require her to go to court and try to sue. And that decision was correct. Some of my best legal advice comes from my mom, and there's something about this argument that makes me want to quote my mom. And because some of what you learn in life, you learn when you're in 6th grade. But they want to go back and say, well, she should have done this, and she should have done that, and play out the scenarios, and why didn't she strike through the language and sign it, which would not have been an enforceable contract, and McIreland considered that. She should have done this, she should have done this, in addition to all of the things Miss Elliott already did to try to protect the MIA. Well, my mom would say 2 can play at that game. Why didn't you just give us the lease we asked for, right? We wouldn't be here today. So they didn't. If you go through the record, what you will see is their representatives just said, no, sign the lease or drop out. No. Sign the lease or drop out. Woulda, shoulda, coulda, 2 can play at that game, and there's one very easy thing. Why don't you comply with the contractual obligation that you signed on to when you bought the units? So we've talked about the facts, and I've given you a picture of what happened and what the hearing officer saw that caused him to reach the conclusion that their back was against the wall and they had to have these units, right? One of the things that Mr. Edwards makes a big deal about is the fact that at some point, Ms. Elliott did reach an attorney in my office. He reads the case law as saying that talking to an attorney completely disqualifies a finding of duress, and that is a gross oversimplification and misstatement of the law. And you don't need to be lawyers to understand, so let me explain what's wrong with the way he is presenting the case law on that front. All of the cases cited to Mr. Ireland and evaluated by Mr. Ireland involved this case of examining duress. And in all the ones where there was no finding of duress, a lawyer was along the way negotiating over time with the client and making the horse trading kinds of decisions. There was a true negotiation between the parties. So take, for example, you're negotiating a divorce agreement. It happens over a period of time. You trade one thing that you don't have to give for something else you don't have to give. You talk to your attorney over time. In all of the cases cited, that's the attorney's involvement. It doesn't say that if you have 10 minutes to call a lawyer, or if you have one phone call with a lawyer, you can never act under duress. So I want you to understand that a negotiated agreement where an attorney provided you advice is what those cases are demonstrating. He also talks about this efficient and subjugating the will of it. And I want you to defer to Mr. Smith on this, and I have utter confidence in telling you, but certainly you can talk to him and ask him questions on conference as to what that means. But there was in history, early on, a theory in the law that duress was this kind of subjugating the will, the hands behind the back, I'm taking advantage of a disadvantaged person. Certainly the mobster, right? But as it evolved to this idea of economic duress. And Mr. Edwards even acknowledged that that's a type of duress. He said economic duress is a certain type of duress. And when the Colorado Supreme Court adopted the standards in the restatement that were applied by McIreland, the Colorado Supreme Court said, you can find it based upon threat and no reasonable alternative. The Colorado Supreme Court does not talk at all about subjugating the will, right? Certainly subjugating the will of someone, and that type of coercive threat would be duress. But there is this other type called economic duress, and it doesn't require it. So Mr. Ireland was completely correct about it. The way he spoke about it, you can tell when you read the opinion, he talked about the Colorado Supreme Court adopting the restatement second, and it makes sense. Putting someone in a position where they can't have what they have to have at the moment is duress. That is economic duress. It is not the type of subversive, arm behind your back coercive, but it is the other type of duress, as Mr. Edwards said.
Just real quick, I just want to be fair to both sides. We're at,
Am I going on?
yeah, we're
I know.
a little bit over time here. So
Okay. I'm actually done, so it's a great breaking point, but I would be happy to field questions here or field questions later, whatever is your desire.
Great. Questions? Board.
Yeah, you said that when the lease was signed, that it was noted that it was signed under protest.
Yes.
Can you cite that in the packet here, please?
Yes.
Sorry?
There should be an exhibit. If
Yes.
you could give it a number, it's,
Page 30 of your packet.
30,
Yes,
page 30, not
page-
exhibit 30, is that right?
That's correct, page 30. There was an error in how the exhibits were put together
see.
later. And so
Okay.
Bethany and I put it here, so it is in page 30. And you should read, Mr. Howenstein, you should read that exhibit in connection with the take it or leave it. You can drop out from renting, which is at 28. And so,
Yeah, and that was another question I had on page 28, Exhibit O. It says that you can, let me find that. Let you drop out from the renting all of the best. Is that supposed to be a typo? Am I supposed to assume that means all of the rest?
there was no testimony whatsoever on the record. Nobody knows what was meant by that. If I assume it's a typo, I think that's
That's
a
the right answer. There's nothing in the record.
There's nothing
to
in the
clarify
record.
that.
Any other questions?
Do you have any questions?
Okay. I think what, if there aren't any other questions, Jody, did you have something?
A couple of real quick comments.
We're gonna let him
Time, if he
vote.
hasn't used his time, he's entitled to.
Go ahead. I think you've got about 5 minutes left.
Okay, first off, I completely agree with Ms. Morrow that you should consult with Mr. Smith regarding what the meaning of the law is. And he should be able to read those cases that we've cited and interpret them for you. I also completely disagree with her interpretation of it. And in particular, with regard to, she was referencing a 1998 Colorado Supreme Court case, which is Vail Arrowhead versus the District Court. And she seems to think that that is the evolution of the law. Well, if you will look, there's also a 2006, which is 8 years later, and a 2022 Colorado case, which is 24 years later, which does use the language I was talking about, actually subjugated the mind and the will of the person against whom it was directed, such that the threat was the sole and efficient cause of signing the contract. And so I request that you consult with your attorney regarding the status of the law in that regard. There were a couple of other things that I think were a little bit misleading or incorrect that I ought to talk about. First is that under protest thing on page 30 of your packet. If you look at page 91 of the packet, you'll see that, let me see if I can find that. And that's a part of the lease. And it says, this lease shall not be modified, amended, or changed in any way except by a writing executed by both lessee and lessor. In other words, an email sent alongside that says, we don't really agree to what we're signing and delivering to you, does not change the terms of the lease. The lease controls. You can't modify it or amend it without both parties agreeing to amend it. The second thing, this whole concept of not being able to rent other than June, July, and August, that there's a couple of places where that shows up as not true. One happens to be on page, what is this, 253 of your record. It's an email from Ms. Christensen to Ms. Elliott. And in it, she talks about APCHA doing rent for, in some of their some of their seasonal housing. So she says, we also start renting Maroldt beginning September 1, so we do get some rent in September, which Highlands could do as well, and even have people stay through part of May. So the point there is that it's not unheard of, and in fact, APCHA does it, to rent outside the seasons for seasonal housing to get extra rent, obviously. You start rent in September 1st when the winter housing people aren't even there yet. It's same idea.
Start rent.
Yes, exactly.
Well, that's not a question, Jody. I mean, they could rent it. There was no question. I mean, the deed restriction says it can be rented shoulder times to anybody, right?
Correct. That's not.
So we're not really questioning that, are we?
Ms. Morrow did. And there's also in your record at packet page 457, MAA testified at the hearing they could rent units all or part of May and September. And they did. They rented part of May and part of September. They signed a lease for parts of May and parts of September. And they testified flat out that they can do that. You know, so the question is, the question is, does it constitute duress under the law, which I hope you will talk to Mr. Smith about what that means. That's all I have. Thanks.
Thanks.
Okay, thank you.
Briefly respond to new points. I will
No
not
problem.
belabor.
At your discretion, Carson, it's not up to me.
Very, very quickly.
Very quickly. I would submit that it is irrelevant, the reference to the email that Cindy Christensen provided. It had her discussion, first of all, she didn't testify at the hearing. And second of all, she was talking about a totally different deed restriction. This deed restriction says June, July, and August. So I just want to point out that it was irrelevant. The other thing that I would point out is what he said about MAA being able to rent during May and September. Everyone agrees that if we wanted them in May, September, if we ever had a need for it, sure, we'd approach the owner and rent it just like the public. The owner can rent it to whoever they want. They just simply cannot force us to take them. They must honor our exercise.
Great. Well, thank you. So if there are no other questions, we will.
No,
Just
no,
answering a
you're
question.
not the attorney,
It's
you may
answering a
not.
question that was fielded that I only know the answer to.
Pardon me?
It was just answering a question that I only know the answer to, not testimony or anything.
It is testimony. You are a witness. You are not testifying
Thought I'd
now.
give it a shot.
No.
Okay, so we.
Can I make a motion? I
Yeah,
guess?
go ahead and make a motion. I just quickly want to say that I think we're going to go into executive session for to talk with Tom. And our plan would be to continue deliberations in public at the June 21st meeting.
June 21st meeting, we have a really long hearing.
Do we?
Yeah.
Well, it just got
It's another
longer.
hearing. I don't know, it's,
We don't have
Up
a
to
first
you.
week of
It's
July
not-
meeting.
not
Do we have a
not
July 5th meeting?
Something
No,
I care
no.
about.
Yeah,
next,
so
the next regular meeting is. the
Should we
first
meet July 5th?
Wednesday in August.
I'm out of town.
I would have to come back for it, yeah.
Okay, well, I guess what I would say is we would continue deliberations at a future meeting to be determined. We'll
Well,
have to
Well, I think it
it'd
should
be
be,
better.
I think that June 21st just got longer.
21st, just do a long meeting.
Yep.
Okay.
It's better to announce a date. If you have to continue it on that date, fine, but it's better to announce a
All
date
right.
now.
So we'll do that. We'll do that. We'll move to the.
Can we confirm that you're available on those dates? I guess, do they need to be here?
You want to make sure they're available. Sure, they can't talk at that time, but it's fair that they are able to be present
And
for
give
the
us mean
discussion.
looks.
Yes.
Yes? Okay. Maria?
It's a Wednesday.
It's always a
And it would.
Third Wednesday of the month.
and
June
it's-
21?
It would
Let me check.
probably be a 3 o'clock
me
meeting
check.
No,
again.
it's a regular meeting date.
Yeah, but
The longest
Hold on.
meeting on the longest day of the year.
And then they just get shorter from there.
hold
So
on.
they deliberate in public, but there's no public comment? Or
No, it's strictly deliberations. They don't take any comments. The law requires that if they're discussing public business
that they do it
as a board, they have to do it in public, but they are not obligated to provide any public input beyond what they've already received.
Tom, do they have the opportunity to ask Maria or me questions?
No.
The 21st works for me.
Okay.
Let's see here. I'm gonna check my calendar, make sure I could.
You
June
should already
20,
have that down.
June 21?
Yeah.
It's already down as meeting.
That's the singer hearing, Tom.
Oh,
Yeah. Yeah.
well, that's not the problem. What time is that meeting starting?
Well, we were gonna start it at 3. I can't imagine us starting any earlier than 3.
Yeah, it may just have to go later.
Yeah, I'll figure it out.
21 to 24.
Okay. Allison, I think I interrupted you when you were making a motion.
I would love to make a motion to go into executive session.
Before we do real quick, Francie has her hand up. Sorry, interrupted
I
you
just
again.
wanted to discuss that date. There, I have to have my hip replaced. I'm not sure I'll be available on that date. And I don't know about Kelly. I assume we need a quorum.
Yes, we do.
Yes, we do.
I will call Kelly right now. I don't know if she'll answer. She's camping. But I'll try.
Okay,
Tom,
thanks.
can Kelly participate? She
Well,
can't
if
hear
Kelly's
us?
gonna participate, she has to listen to the tape.
Okay.
Because if she wasn't on for live arguments, she can't.
There's,
Vote
okay, there's a
without-
good chance I'll be available. And do you need
Ideally, you
one of
both
us to
are.
be in person? Or I'm just wondering if I'm
No,
You
not
don't have
able
to be in
No.
person, but you have to have
Okay.
heard all the arguments.
You gotta be coherent, you can't be.
Yeah, I don't think you should be under the influence.
of, drugs from the hospital, you mean?
yeah,
Yes.
Right.
Well, I don't even have to stay overnight, so I think I'll probably be available, so hopefully I'll hear back from her shortly. Let's go ahead with June 21st.
Let's just go with it, and then we see
Okay.
what happens.
Yeah,
Great.
go with it.
All right, Allison, third time, I promise not to
I'm
interrupt.
gonna mess it up now that I'm on the spotlight. I'd like to make a motion to go into executive session for a conference with the APCHA attorney for the purpose of receiving some legal advice and/or just
got the-
clarification.
Is that statute number
Under
you're
C.R.S.
supposed to
section
mention the
24-6-402-4B regarding the public hearing on
Okay.
the Appeal of Highlands Villas LLC, please.
And not for the purpose of deliberation.
Okay, yeah, we
Second.
have some questions.
All right.
Is there any reason for us to stay around?
I think that's why we're
There
putting
is
it
not.
off, or we could do it all tonight, but that you guys would have to stick
It's
around for
not
quite
gonna
some
happen
time.
Yeah.
tonight.
There will not be any
And he has to
additional
write.
agenda
Yeah.
items after the executive session.
Yeah, it's not.
There was a second.
So we have a second from John Ward.
Yep.
You need a roll call vote?
Please.
Yes.
Francie,
Yes,
Ward,
Yes?
Carson,
Yes.
Allison?
Yes.
John?
Yeah.
All right, so we will move into executive session. So if everyone would clear the room.
This doesn't need to be recorded.
Yep, and thank you for your time.
And you want us out as well?
Thank you.
Tom,
Tom, you need
Tom,
staff
we're
out as
leaving?
well.
Pardon me?
we all leaving, staff?
You work for the board, you have the option of staying or
I have one
Or not.
question,
Recording
and then I
stopped.
could probably send you away.
Okay.